Okay. Good morning, everyone. If you could come on in and find a seat, that'd be great. We're going to get this press conference started. My name is Phil Robertson. I'm the director of the Asia Human Rights and Labor Advocates. And I'm going to be your moderator today in addition to being a speaker. We're going to, I'm going to allow each of the speakers to sort of introduce themselves as part of the discussion so that to not waste any additional time. And I'm going to first ask Quynh Bdap, who is Bergman, who is the lawyer for Quynh Bdap, to speak about the situation. Then we're going to turn and hear more about the refugee situation, transnational rights, and what would happen to Quynh Bdap if he's sent back to Vietnam. So let's kick it off with Nat.
Thank you so much. Natasiri Bergman. I am a lawyer from a Human Rights Lawyer Association. I also work on the immigration and extradition case. For Quynh Bdap case, the case was referred to me by CAP. They was been working with him on resettlement. And on the 11th of June 2024, this year, CAP reached out and said, I need you to work on this case. And one of the client was arrested and detained at the Phahon Yotin police station. And then turned out the person was already UNHCR recognized refugee. And then he was informed of the charge, of the terrorist charge, and the police have the warrant to arrest from criminal court, and they was gonna charge him. They want to arrest and detain him for the extradition. On the following day, he was informed of the violation of Immigration Act, and a few days later, on the 13th, the Thai government received an official request from Vietnam, and the extradition process started then. On the background of the case, Mr. Quynh Bdap is a member of the group living in the central highland of Vietnam. He is from the ethnic group called Ade, and he's practicing religion. Most of him and the people in the central highland that is practicing the Christian religion, we are collectively call them a Montagnard people. Bdap was having a problem ever since he was young. Not only that, his father was monitored and followed by the authority from Vietnam, his grandfather also have been monitored. Is on the list of the watch list of the people, because his grandfather was working for the U.S. military during that time, and he was not only practicing religion in that area, he get a good education, and because of that, he been teaching Bible for the people within that area in his house. So the one of the problem that the people in Central Highland Vietnam have is you are not allowed to practice any religion until you register with the government. For the ethnic minority, that could be a problem because they have difficulty obtaining the ID card or house registration. When they are trying to register with the government, they're facing a lot of harassment. Most of the government officials would not want you to practice any religion. Since Bdap was in his high school, he was calling for the government to allow the people to practice religion freely. In 2012, he was picked up and detained and interrogated for 5 months without any lawyer. And at the end, the authority want him to sign the letter saying that he will not again practice any religion, will not continue to disseminating all the information and will not gather. But he is a true believer. He continued to practice his religion. and learn a lot more about freedom of religion and freedom of expression. And the problem continue. In 2016, he learned about the meeting in Thailand where he was invited as a speaker to share his experience of as a Christian montagnard, what is happening on the ground. And he come to Thailand for that meeting. Returning back to the country, he was detained again. This time is for 7 days, every day asking who are you meeting, what information that you give, is there any information that you want to give to the authority. And his house was raided, and he went out and worked, and then the police come raid his house, and he was afraid. Since 2016 up until 2018, the monitoring, the raiding continued, and he was picked up, he was attacked. During all of those times, he will be threatened that he will be disappear, and if he wanted to leave, he have to stop practicing religion, but he did not. So 2018, he fled to Thailand and start process of applying for the refugee status with UNHCR in 2019. Right after he arrived to Thailand, he set up the organization as a founder of Montagnard Stand for Justice. This organization works solely collecting information about the refugee that fled Vietnam and the problem that they are facing in Vietnam and what is the root cause of the problem. And Montagnard Stand for Justice have submitted a report, the situation report to many organizations. This is including UN, resulting more than 100 report was submitted, and he become very vocal. And even the US government also issue the report on the region freedom in Vietnam, and the universal review from the UN, they also give a suggestion that Vietnamese government need to better care for the Vietnam people. This is the cause that why he become targeted. So on the 11th of June 2023, there was an attack on Douglas police and resulting in 9 casualties. And right after that incident, there was a roundup and for the suspect. 100 of people were identified as the culprit, and 95 of the suspect arrested confessed at the police level without any lawyer and without any interpreter. And at the end of the investigation, the trial was set up. 100 people was found guilty, including Bdap, with the 5 people that found guilty in absentia. Bdap he denied any connection. However, the Vietnamese government announced that Montagnard Stand for Justice is a terrorist group, and then the extradition process was started right after, and they render the judgment on 24th of January this year, and he was found guilty and with the 10-year imprisonment imposed on him. On the 11th this year, or June this year, since he was arrested, and used that based on the case that was in Vietnam for terrorism. And we are trying to, our argument that in the extradition case, he cannot be extradited because he's a recognized refugee. And one day during he was during the resettlement process. One day before he was arrested, UNHCR was asking for him to come in and give an interview if he have any connection with the incident that happening in Douglas, and they found no no evidence that he connected, and his status was never revoked, also he's still confirmed as a refugee. All of this information we use in defending our case in the extradition case. However, is sadly that Thai court only make a ruling that for the extradition, because we do not have the bilateral agreement for the extradition with Vietnam, we are going to follow strictly the Extradition Act, and the section that the Thai government use is section 19, which is only giving full condition for the court to detain him for the extradite. Is firstly that all the process have to go through the diplomatic process, meaning it have to go through that channel, or the step or the document have to be certified and translated and submit to court, sent to the Ministry of Foreign Affairs. In this process, the Ministry of Foreign Affairs should consider whether or not this case is have enough ground to meet with the law requirement for extradite. If the Ministry of Foreign Affairs see that it could be extradited, it will refer the case to the Ministry of Justice for the Attorney General Office, and then the Attorney General Office submit the case to court. This means that they already look at all the information submitted that it meet all the requirement. The second requirement is that the Thailand charge, the Vietnam law, the charge that he charged in Vietnam, and there is the same charge also in Thailand with the terrorist charge, and all the elements are met, which is the proof is that through the element of the terrorist act violation, the terrorist charge are met. The third one is the person that was charged and convicted is the same person that arrested in Thailand, which is the information that he is the same person, but he's denied any connection with the terrorist act that is happening. And the last one is the extradition was requested within the time limit. So this is strictly what the judgment was made on the 30th of September. Our argument that is for the there is an existing law and the international obligation that Thai should follow is a anti-torture convention that is Thai a member party to, which is we enacted, and we have anti-torture act in Thailand, in which anti-torture act section 13 prohibited any government authority to send any person to extradite or any person back to the country is that they fled from. Is a international non-refoulement principle that is already written clearly in Thailand. Sadly, even though the judge said that they recognize him as a refugee, they recognize that there is already existed anti-torture act in Thailand, but the judge said that they are not competent to make a ruling whether or not at this level that he should be extradited, because strictly speaking, the judge said those are in the hand of the executive, is the power of the executive branch. So for now, after reading the judgment, I talked with Bdap, and he is so afraid that he will be sent to Vietnam, and he asked that we should appeal the decision. And now we are waiting for the full complete judgment so we can work on the appeal. The court order said within 30 days he cannot be extradited, but that 30 days only if after all the court proceeding is completely finalized. So he will not be extradited if we request for the extension to submit our appeal. that is the extradition case. So I think the judge is making an error because in all of the law within Thailand, the one that is most fit, most competent to invoke, especially when we raise during our trial that there is already existing law. They have to make a ruling on that. But this is the case that we have to continue working on. Currently, there is also a continuing case that is happening at Don Mueang Municipal Court. Is a violation of immigration law because the charge was entering Thailand illegally and staying in Thailand illegally. This is the common two charge that we use against the refugee that's seeking asylum in Thailand. But this, if they look at it this way, it will not give any asylum seeker any peace of mind because anybody can be picked up and charged and be deported out at any moment. So we are trying to argue that most of the asylum seekers, they are entering Thailand because of the necessity. They fled because they need a safety for their life. They do not want to be in Thailand, but it's by necessity they are staying here and they are waiting the resettlement process. The hearing in the municipal court will be on the 17th and 18th October from 9 a.m. to 4 p.m. If you're so interested, I am inviting you to observe the trial. It will give huge support to him there because he is all alone. Thank you very much, Kun Phil.
Thank you, Quynh Bdap, for that very comprehensive explanation of where the case is and what are the key aspects of Quynh Bdap's background and how he ended up in this situation. Next, we're going to turn to Kun Kritiporn Semsantat, who is the program director of the Peace Rights Foundation. She's going to talk a little bit about some of the principles of refugee protection.
Thank you. Thank you. I would like to kind of affirm what Kun Natalie just said, that Thailand has a legal framework and also international obligation to comply with, even though they are not, Thailand is not a signatory state of the Refugee Convention and its protocol. So simply I would just say like Thailand can protect refugee without being a signatory state, and that it doesn't require like a heroic action or like a very bold decision to refuse such request from extradition of the refugee, because we have legal framework and international obligation already in place. Like I said, we are not a signatory state of the Refugee Convention, but it's not the end of the story that we doesn't, extend our international protection to the refugee. We have customary law, international customary law, the non-refoulement principle, which is the strongest, like, I'm not a legal background, but let's say like this is the principle that every state is widely accepted to be upheld. And not only this customary law, but we also have other international human rights law that we are the member of the signatory, which is Convention Against Torture and ICCPR, which has stated really clearly about the non-refoulement principle. So this is what I want to put it out there first. And let me begin with how Thailand would normally deal with refugee and asylum seekers in Thailand. Even though we don't officially recognize refugees on paper or whatsoever like official announce that we have refugee, but we always have de facto refugee in Thailand. We host about thousands, 100,000 of them in the border, and also we have 5,000 each in urban context. And in the past decades, we kind of reintegrate them somehow with the Thai Jin Ho or like Laotian or even Vietnamese refugee in the past that are waiting for the legal recognition in Thailand. You can see that this is how we deal with the refugee situation in Thailand. Even though we're not a signatory, but I don't know, it might be some kind of, you are not like officially endorse this convention, but you also have room for them to be protected in Thailand. So I would like give some example on let's say like international recognition that we have. It might seem ironic, but in 2016, General Prayut Chan-o-cha, the Prime Minister of Thailand at the time, had attended the Leader Summit on Refugee held in the United Nations headquarters in New York, and at the invitation of the President Barack Obama to join the world effort in pledging additional assistance for displaced persons. Not only Thailand is the only ASEAN country that will attend at time, there have been like this invitation is kind of the testimony that Thailand has been long-standing support in humanitarian assistance toward over 1 million displaced persons from various countries during the past 4 decades. And also, he also had like additional pledge on having like a screening mechanism in order to don't let anyone to falling under human trafficking or a non-refoulement principle. So you can see that there's a lot of official recognition towards upholding the non-refoulement principle. So that's what we consider this case as. Extradition Act is also a legal framework, but as well as other international obligation and Anti-Torture Act and other policy that we have been developing towards taking care of, extend the international protection towards the displaced person or whatever you call they are refugee, no matter what you call them, like individual who cannot return to the country of origin or whatsoever. They have the ground base of refugee, that they have well-founded fear. They have well-founded fear on persecution and cannot be returned to their own country based on their race, their religious, gender, part of social group or political group. So that's what we would advocate for Quynh Bdap case. And we're back to square one on non-refoulement principle, which is saying like when you find this person can be harmed or persecuted, when we send them back to the original country, there's no better proof than having recognized as a refugee by UNHCR. UNHCR status, refugee status determination is a tailored interview, like individual interview, individual validation of their refugee claim, and they have the country of origin information that have said and validate all the refugee claim of this person is this individual. And I think that this is the ground that we could consider the non-refoulement. And I wouldn't go toward the crime committing part because the refugee status is still there. There's no revocation or cancellation. So we would consider the status of his refugee status in the first place and recognize and we provide international protection. And what's next is when we consider the durable solution for refugee and asylum seekers, there's three solutions. First is resettlement in the third country, local integration, and voluntary repatriation. I will stress on like voluntary. And this case clearly there's no voluntary and there was so there's no voluntary obviously. So sending him back or extradite him would break this ground of how you identify the durable solution for refugee. Do I have more time left?
I think we should probably move on to the next speaker unless you have something.
Yeah, like just
Okay.
saying like Thailand has both like moral duty and legal obligation to protect individuals or refugee or whatever you call from persecution and harm. But most importantly, in considering extradition of refugee, state bound to ensure full respect for the principle of non-refoulement under Anti-Torture Act and in the other international human rights law, because extradition is an implementation of non-refoulement principle, must be coordinated in such way to enable state to rely on extradition as an effective way to combating transnational crime or impunity in a manner which is fully consistent with the international protection obligations. Thank you.
Thank you very much. Very helpful. We are live streaming this on the ASEAN Burma's Facebook page. I understand there's been some interruptions possibly connected to the internet quality. I apologize for that. The FCCT will also, I think, put a copy of this up on their YouTube page after the actual press conference is done for people who have not been able to see it or want to see it again. Next, I'm going to turn now to Quynh Bdap, Pruksa Kemsamsuk, who is the Deputy Executive Director of the Cross-Cultural Foundation, who's going to speak a little bit about the issues of transnational repression and how this case fits in.
Okay. Thank you so much, Phil. So good morning, everyone. Again, my name is Quynh Bdap Pruksa Kemsamsuk, and I'm currently working with a Thailand-based human rights organization called Cross-Cultural Foundation, or CRCF. And today I'm speaking as a human rights advocate who has been following closely the case of Mr. Quynh Bdap. And in fact, CRCF, we have been documenting the numerous cases of transnational repression. And that is going to be the main topic I would like to cover today. And just to go back probably to the basic definition of transnational repression, or TNR. Basically, it's a state practice to violate and abuse their own nationals or citizens outside of their own jurisdictions, and the forms are diverse. It could range from a phone call to threat the victims' families, harassment or surveillance, direct attack, assassination, or the most severe one, enforced disappearance. And these acts could be directly committed by the state officials themselves, or an assigned person, or a group of persons, a hired person, for example, with or without legal processes, as in this case is through the Thailand legal process of extradition. And we all know how widespread this violation occur in the region of Southeast Asia. And for Thailand, we have begun to observe, as Katie already mentioned a little bit about at least 9 cases of Thai political refugees in neighboring countries, such as Laos, Cambodia, and Vietnam. At least 3 Thai political refugees has allegedly disappeared from Vietnam in 2019, namely Siam Thiravut, Chuchip Chivasut, and Grisana Thapthai. So from what we have learned in these cases, TNR cases, there are existing patterns of abuses and violations, which also happen to most of the TNR cases, including Mr. Quynh, who is now facing a different form of TNR, the extradition. It all started with the history of political activism against one nation's government. No matter what kind of advocacy it is, in most Thai cases, they were advocating for democracy, they were against the authoritarianism, and for some, against the old regime that is linked to the military and the Thai monarchy. And apart from the 3 cases who disappeared in Vietnam, as I mentioned the names, we have 4 more who was lastly seen in Laos and Cambodia, and 2 were found dead in the Mekong River, the natural border between Thailand and Laos, reflecting probably what could be the fate of all the remaining missing persons. So all these 9 people shared some commonalities. They were prominent activists targeted by Thai military government who ruled after the coup d'etat in 2014. And that is the official evidence, which was, for example, the junta arrest warrants. And in some cases, such as one Chalerm case, who was forced to disappear in Cambodia in 2020. We even found an order from the police cybercrime unit to find his residence in Cambodia. So, well, these are probably the most extreme cases of TNR, enforced disappearance, because the main problem of these cases is the lack of evidence to prove the TNR committed by the state. So nothing, all is gone, and their fate is still unknown. It is really problematic and difficult for us and the families to seek justice with the, with the Thai government or even with the host government like the Cambodia, Vietnam, and Laos. We are not even able to request for a mere investigation or recognition from the state. Now I'll come back to Mr. Quynh. The similarity is the same. There were signals of threats and harassments prior to his arrest. And his stories, as many of P. Natalie already shared, it told so many things. He was advocating similarly to our Thai cases for freedom of religion and belief, something that is strictly disapproved by the Vietnamese government to the point that could put his life at the stake. He was arrested, beaten, tortured so many times before he decided to flee to Thailand. And this is according to the report and interview with him. So the history of past violations has already proved the potential risk Mr. Quynh may face of his freedom and right to life. When he is in Thailand, from what we have discussed and exchanged with the legal team and other CSOs who were helping him, there were acts of cooperation between Thailand and Vietnam in Thai soil so long before his arrest this year. For example, in March 2024, there are reports that the Vietnamese police and security force came to Thailand after coordinated through the Ministry of Foreign Affairs. They were scouting the Vietnamese refugees community, asking around whether some of them would like to come back to the country since the situation is better now whatsoever. But the actual objectives of this practice was to seek information about the residence of Mr. Quynh, where he lives in Thailand, and because this information is necessary for the extradition request. So all these alarming threats happened several times, and then he was arrested according to the timeline given by P. Natalie just earlier. It's pretty unacceptable and scandalous how such cross-border operation was allowed in Thailand, and even in the court, as I was observing many hearings, there were presence of Vietnamese officials in every hearings. I mean, is this a sign of intervention or just a strong friendship between Thailand and Vietnam? Who knows? But some may say that Mr. Quynh was lucky that he was arrested, detained, and had to go through the legal processes. But in our observation, this luck is just not possible without the Thailand newly enacted law, already mentioned so many times, the Prevention and Suppression of Torture and Enforced Disappearance Act. And there are several provisions in this law criminalizing torture, ill treatment, and enforced disappearance. And this is universal jurisdiction, absolutely prohibited. And why is it really relevant for this case? The Section 13 states that no state agency or state authority shall expel, return, or extradite a person to another state if there are substantial grounds for believing that person would be in danger or being subject to torture. So the most important key here is the substantial grounds. We don't really have to prove so much that he is going to be tortured. His past history, the past violations that he experienced already enough for the substantial grounds. So this specific provision actually has some effect to the decision of the court, and now as already provided by his lawyer, the judiciary is basically throwing the responsibility to the government to decide whether he would be sent back or not. And well, this is unprecedented, but just with this new law, we have some more time to take action and to prevent such violation to happen. And again, it's still really problematic since the law is so new and we don't have any precedent in interpretation. So every decision, whether from the court or from the government in the near future, is need to be monitored closely. Also, another potential factors, maybe PFU will cover this part, like the Thailand commitment to bid for Human Rights Council, may also have some effect on this decision and the fate of Mr. Quynh. So I'm going to go to the last part now. We could actually stop this to happen. We could prevent this. And this is not just an attempt of the CSOs, human rights defenders. It is actually an obligation of the Thai state not to extradite Mr. Quynh. Otherwise, it is evidently a violation to our domestic law, the Article 13. As well as so many international instruments, including what Katie already mentioned, ICCPR, Convention Against Torture, to which Thailand is a state party. And just another key aspect I would like to mention is about the ASEAN instruments, which also address this issue about cross-border human rights violations. And well, why we are trying to stop TNR with so many existing mechanisms, so many cases keep happening. I just want to mention the recent cases of hundreds of Burmese people who are sent back to Myanmar, despite the fact that the Myanmar leader is forcing a lot of people to join the soldier conscription. It also affects the women and girls who are also need to join the conscription. And also another recent case of Cambodian woman who is sent back to Cambodia for criticizing the Cambodian government just a few days ago from Malaysia. So, well, I'm just gonna conclude that so many things is happening around Thailand. Like the ASEAN summit is happening right now. Thailand is also gonna be reviewed by the UN Committee Against Torture in November, and also the Human Rights Council today. So are we gonna let such preventable violation to happen again in Mr. Quynh case, taking into consideration all these, situation on Thailand? So I'm gonna end here, and I urge everybody who is listening to monitor closely this case, as well as other cases happening in our region and at global level. Thank you.
Thank you very much. Very comprehensive discussion about transnational repression in the region and in Thailand. Good morning again. My name's Phil Robertson. I'm the director of the Asia Human Rights and Labor Advocates. You've already heard from my colleagues on the panel about Thailand's important obligations to follow customary international law on refugees. Under no circumstances should Thailand send a refugee back into harm's way to face persecution, as the Vietnamese government has blatantly and continually pressured Thailand to do so in the case of Quynh Bdap. You've also heard about the serious international cases of transnational repression that have occurred in Thailand and the region, of which Quynh Bdap is also a very clear example. And if Thailand wants to sit as a member of the UN Human Rights Council in Geneva, it needs to consistently stand up for human rights principles. And that includes pushing back on bad advice and refusing sinister requests from rights-abusing neighbors. There is an expectation that member states of the UN Human Rights Council should uphold human rights principles, not violate them. And for this reason, Thailand should be part of the solution, not part of the problem. And what happens to Quynh Bdap will be a very important way for the international community to determine which side of the human rights fence the new government in Thailand is going to stand on. Now, we had during the previous governments, the previous military government of Prime Minister General Prayut Chan-o-cha and Deputy Prime Minister General Prawit Wongsuwan, they operated a sort of swap mart in the years that they were in power, where they were willing to do deals with abusive, rights-abusing neighboring governments to force refugees who had fled to Thailand back to face persecution in their home countries, to face abuse, to face long prison sentences, to face enforced disappearance. You know, and that was deals done with China, including on the cases of the Uyghurs, Myanmar, Laos, Cambodia, Vietnam, Malaysia, Bahrain, Saudi Arabia, Turkey, you name it. I mean, the store was open for refugees to be sold off by Prayut and Prawit for whatever deals they were going to get. And you can read all about it. Human Rights Watch wrote a report about it called "We Thought We Were Safe: Repression and Refoulement of Refugees in Thailand," talking about some of these cases. That was released on the 15th of May, and it's on the hrw.org website. But this was supposed to change with a newly elected government from the May 2023 election. You know, we had the Move Forward Party won the most votes. Pheu Thai Party is the second level vote getter. And even after MFP was pushed out, you know, there was an understanding, there was sort of a new deal that emerged that if Thai officials arrest a refugee and activists and embassies put pressure on the Thai government saying, look, this guy's a refugee, this woman's a refugee, don't send them back, then Thailand would respond to ensure that the refugee won't be forced back to their own country. You know, a sort of kindler, gentler approach, a break from the bad old days of Prawit's wheeling and dealing with refugee lives. But Quynh Bdap is a test case for this new policy. You know, it's a test case for the new policy about refugee protection and for against transnational repression. And this is a test case for the government's credibility on protection of refugees. And it is also a test case for the new law on prevention and suppression of torture and enforced disappearances, which came into effect in February 2023, which, you know, the Thai prosecutors in court shockingly threw aside as if it didn't matter at all. And this triple test case phenomenon of a new deal on transnational repression, protection of refugees, and this new law, which was much heralded and which has been a core part of the Thai government's campaign for a seat on the Human Rights Council. This triple test case phenomenon, along with the very serious concerns about the rights abuses, the severe rights abuses that Quynh Bdap will face if he is sent back to Vietnam, is one of the reasons that this case is so now prominent internationally, and why so many governments and legislators and activists are all intervening to tell the Thai government that they cannot send Quynh Bdap back to Vietnam. You know, and we've seen so far a statement by the National Human Rights Commission of Thailand. We've seen a number of communications by UN special rapporteurs, the UN experts on human rights, to the Vietnamese and to the Thai governments. We've seen letters from the US members of Congress to the Thai government raising concerns. There have been amicus briefs filed to the Thai court. There have been numerous joint statements by international human rights groups. There will be, I think, another major international letter to the Thai government probably next week about this case as well, which will, I think, include many of the major international, regional, and national human rights organizations. And since prosecutors, however, and the court ignored that law that I was mentioning, and have essentially sort of pushed aside concerns about Vietnam's horrific human rights record, including systematic use of torture and detention, and instead accepted Vietnam Ministry of Public Security assurances that were, in my view, not worth the paper they were written on, let me say a few words about Vietnam. First, Human Rights Watch, my previous employer, documented that beatings and torture are systematically and pervasively used in every step of the police custody process in Vietnam. It's not just political prisoners who get this, but also ordinary Vietnamese who run afoul of the law for traffic violations, resisting arrest, personal disputes in the community, theft, you name it. In fact, there was a report that was done by Human Rights Watch. It's called Public Insecurity, Death in Custody and Police Brutality in Vietnam. And it found clear cases of police torture and abuse in more than 44 of Vietnam's 58 provinces, and in each of the country's 5 largest cities. So basically the way the Vietnamese police operate is they interrogate suspects by beating them up and seeking to extract confessions. And this is completely ingrained in the Vietnam judicial system, and there is impunity in cases where police torture results in deaths in custody. A group of 14 independent UN special rapporteurs, including Ben Saul, the special rapporteur on the promotion and protection of human rights and fundamental freedoms while countering terrorism, stated in July 2024 that, quote, "We believe that if extradited Quynh Bdap would be at risk of enforced disappearance and torture or other ill treatment and punishment in violation of non-refoulement." So it's astonishing to me that somehow the Thai court didn't consider the new anti-torture law to be relevant to this case, because you're talking about sending a refugee back to Vietnam. And you have international experts who are saying very clearly that torture occurs on a regular basis in the judicial system and in the police custody system. But, you know, the Thai prosecutors didn't listen to that advice, and they listened to, I think, empty Ministry of Public Security assurances from Vietnam that Quynh Bdap would be treated humanely. And as that same special rapporteur, Ben Saul, noted in his amicus brief to the Thai court, which was apparently also ignored by prosecutors and the judge, he said, quote, "In the case of refugees, assurances given by the state of origin cannot lawfully be relied upon because the state of refuge has already determined that a person is a refugee. And according to UNHCR, it would be fundamentally inconsistent with the protection afforded by the 1951 Convention for the sending state to look to the very agent of persecution for assurance that the refugee will be well treated upon refoulement." Now, we understand that the Vietnamese government has the plan to send Quynh Bdap to Gia Trung prison, which is in the highlands. It's notorious. It has a long history of guards abusing prisoners, including my friend, citizen journalist Quynh Bdap, who was beaten up there. And I should also note that Vietnam has a long record of discriminatory treatment against Montagnards in the Central Highlands, which includes hostile surveillance and intimidation, arbitrary arrests and serious abuses in custody, severe restrictions on freedom of expression, association, and public assembly, restrictions on freedom of movement, denial of ethnic identity and freedom of religion, land seizures, and of course, the introduction of lowland settlers onto Montagnard historical lands. And the bottom line is that the Vietnamese security forces, and especially the Ministry of Public Security, has a myopic and antiquated policy view that treats virtually all Montagnards as separatists and traitors trying to undermine national unity. Important to note that they are still accusing Quynh Bdap of being a member of Fore, an organization that ceased to exist in 1992. And they argued at the trial that the attackers were trying to create what they call a Daga state, which is the Vietnamese MPS terminology for a separatist state. Whoever is responsible for the June 2023 attacks in Dak Lak, I mean, they did essentially confirm the worst fears and prejudices of the Vietnam security forces, And the response has been a whirlwind of retribution against the Montagnard people, including mass arrests and abuses in custody. And shockingly, the Thai prosecutor also failed to even consider whether the mass trial in Vietnam was free or fair. In fact, it was not free or fair. Thai prosecutors gullibly accepted assurances given by visiting MPS officials who met with prosecutors before the trial and took those assurances at face value. Furthermore, those assurances apparently included that Quynh Bdap would be treated humanely if forced back to Vietnam. It's important to understand that the trial at which Quynh Bdap was convicted in Vietnam, convicted in absentia, was one of Vietnam's new mobile trials, in which trials are held in the community to embarrass or shame the defendants and intimidate the community they originate from. In August 2024, 14 UN special rapporteurs stated that the mobile court proceeding, quote, lacked a clear legal basis and was not independent of political influence, unquote. And 100 suspects, including Quynh Bdap, were convicted of terrorism-related offenses in that 4-day trial. Many of those were, by confession, presumably beaten out of them, given the way that the Vietnamese security system works. And that's the way the Vietnam judicial system operates. There's no independence whatsoever, either from the government or the party. That's why Vietnam has the second highest number of political prisoners among governments in ASEAN, after Myanmar, with over 160 behind bars, according to Human Rights Watch, and more than 200, according to other human rights groups. Now, Quynh Bdap has strenuously denied being involved in any of the violence in Dak Lak, but the Thai prosecutors didn't even allow him or his defense to make that case about his innocence, or about the Vietnamese government's use of torture, or about the lack of independence of the Vietnamese courts. So there was clearly a travesty of justice in the Thai court, just as there was a travesty of justice in the Vietnamese courts that initially convicted Quynh Bdap. Now, the Thai Prime Minister and her government have the ability to right this very clear wrong that has been done to Quynh Bdap, and they should make the decision that Quynh Bdap will not be returned to Vietnam. And they should state that very clearly, and they should basically state that at the UN Human Rights Council, if in fact they are elected to that August body later today. So with that, I want to thank you all for listening to our overly long presentations. We're going to open the floor for questions and welcome any questions. If you do have a question, please identify yourself and the organization that you're representing, if any, and also indicate who you're sending the question to. And the floor is open. Please use the microphone behind you. There's a microphone there. So.
Hello, everyone. I don't know if I'm, yes. I'm Manaz Houani. I am from the Dutch Embassy. We are monitoring this case very closely. I want to thank you all for this very informative talk. A question that we have at the embassy is whether the Vietnamese government released any evidence of his alleged interference on the terrorist attack. And whether or not you know a little bit more about that.
Okay. So the question is whether the Vietnamese government has released any evidence implicating Quynh Bdap in this terrorist attack that took place in Vietnam, and do we have any information about that?
Okay, so the information we receive, including the judgment that is of the mobile court, in the judgment review 3 defendants in the case accusing him of directing, ordering, and planning the attack. But there is no other evidence than the accusation from the defendants that giving during the police investigation, and that suspect during the police station also did not have a lawyer and did not have. They said they did not want a lawyer and they did not need a translator, so they just give the accusation to the police and sign. That is the document. Another document that's supporting the judgment was the picture of the damaged police station and the picture of the casualties of the people that was died on that night. But there's no other anything that is really linked to Bdap.
So we just have, so basically they have 3 statements by defendants at trial saying Bdap was involved, but no other evidence.
Have a picture that said this is the result of his directing the order.
Right, but, okay, but there's basically no evidence that shows that he communicated, there's no anything.
Correct.
Okay. So again, an allegation based on interrogation of some of the other people who were in Vietnam. Yeah, please, if you have a follow-up, go ahead.
Yeah, so just if I understand correct, like the 3 people that were interrogated, they had no translator and they had no lawyer, if I understood correct.
Did the 3 people who made the accusation against Bdap have a lawyer, or did they have translators?
They do not have. It was given during the police investigation, interrogation. So the whole 95 people that giving under the investigation, they did not have any lawyer at all at the police level. The lawyer was appointed to them during the court proceeding, but the only thing that the lawyer did was asking for the leniency of the sentence.
Good morning, everyone. I'm Mi Hằng from the BBC Vietnamese. Thank you so much for the very productive, informative presentations. So my question is for field repression. Do you think that Quynh Bdap's case will be the test for the Mr. Tho Lam in his position as the Vietnam's new president and general secretary of the Communist Party of Vietnam? Thank you.
Okay, I'll answer that, and others can answer as they want as well. Unfortunately, I have no confidence that the new president, Tho Lam, will do anything different as president than he did as Minister of Public Security. You know, I mean, he was Minister of Public Security when this entire investigation was going on. You know, there's been a remarkably little information that's come out about the attacks in Dak Lak beyond, you know, the official narrative that this was some sort of overseas plot launched by people with intention to split the Central Highlands away from Vietnam. You know, who was attacked, how was it attacked, what happened? There's very little information about that. The allegations are simply that this wide group of people were somehow involved. And the fact that there's a lot of confessions indicates only to me that the defendants were probably treated very badly in detention because, as we know, torture is a regular part of Vietnamese police interrogation techniques. It's actually a core part of that. And the system is organized and oriented towards securing confessions so that once you get to court, you know, they just produce the confessions and then the actual sentences are pronounced. It is not, in my view, a system that is actually focused on gaining the truth. It's actually focused on understanding and gaining persons who can be blamed for something that happened. So Tho Lam will do, I think, very little different than his predecessor as President and Secretary General of the party did on these cases. He will ultimately, you know, continue to, I think, direct a very security-focused approach towards the Central Highlands, which means going after particularly the Montagnard diaspora, the refugees who have fled to Thailand are trying to find protection in a third country. The question is whether this will be part of Tho Lam's legacy for Vietnam. Tho Lam is the president. Other questions, please?
Hi, I'm Ken, reporting for Heart Stories. I just want to know why the Thai government has been so silent if this is against their interest to be in the UN human rights seat.
Okay.
For the whole panel.
Right. So the question is, why has Thailand been so silent when this case obviously will have an impact on their bid for the Human Rights Council?
Well, they would say something like we are waiting for the flooding in the north to like reduce or something like that. But yeah, I mean, we also, I mean, from CRCF and the network of CSOs, we also work with Ministry of Justice regarding this case, and it seems like they would say something about the international relationship, and it seems like something that couldn't be public or be spoke non-top of the list.
From my courtroom experience, the government is trying to make this, the prosecutor is trying to make very clear this case is not a politic case. You know, they're trying to shift this into the judicial only. So it's not in the hand of the executive or the government to intervene. So even when we talk with the Ministry of Foreign Affairs, the representative said this case is within the court hearing, so they are not going to win. They do not want to see as the intervening the court proceeding. And this is the argument that have been using in this kind of cases, and this is also the same with this case.
I think that what is happening is that Vietnam is pressing Thailand very hard to send Quynh Bdap back. They've decided that, you know, he as a prominent Montagnard human rights activist is someone that they want to blame for what happened in Dak Lak. This is part of their narrative to say that this is being orchestrated from Montagnards overseas, and that nothing that the Vietnam government did caused the problem. It's just people of ill will outside the country want to do this. And so what we've seen, however, is that when Thai government gets pressed very hard by one of its neighboring governments, it tends to retreat and then accept the narrative that's being presented to it, unless there's an alternative countervailing coalition or group of people who are saying, in fact, what the Vietnam government or whatever government we're talking about is saying is absolutely wrong. And that is where we are here right now. We're moving towards a sort of tug-of-war process where, on one hand, Vietnam is pressing their case very strong with the Thai government. On the other hand, the international community and others are recognizing that this is a very clear case of injustice, and that, in fact, if it goes forward and that Quynh Bdap is sent back, that it will tarnish Thailand's human rights records in a very significant way. And how this plays out depends, I think, on the UN, on various different embassies and governments that are, you know, have representatives in Thailand. It will also depend on assessments about whether, in fact, you know, he would be tortured if he was sent back, which we believe he would be, but which the prosecutor didn't want to listen to or didn't want to talk about. What is very interesting is that the prosecutors seem to have an approach to this process of focusing just very clearly on the extradition treaty and then putting their hands over their ears about everything else that was wrong with Vietnam or with their case. And that's a problem. I mean, you know, you would expect that a prosecutor would want to have all the evidence available rather than try to deliberately restrict to themselves what they're hearing and what they're learning about. You know, it raises some fundamental questions about that prosecutor.
Hi, my name is Quynh Bdap. I'm from Solidarity Center, so we work mostly with trade union. So my question probably like probably mainly to Phil, but also other panelists welcome to answer. I'd like to ask probably like in the aspect of United Nations, the Human Rights Council to be exact. Like, so we've been, I think people in Thai CSO like network, since we heard about this, so most of it is only like criticism, like why, I mean, Thailand has so many problems in terms of their own human rights, and why would it want to be in the UN Human Rights Council. And I mean, like some of you might have heard the explanation from Thai government. That's probably like qualified from the most unintelligent answer ever, such as like, yeah, we have problem, but other countries have problem. So, I mean, like two wrong make a right, those kind of things. So my question was like, what if Thailand actually like make it to the Human Rights Council? What kind of damage would it do to the Human Rights Council, or is it something that people don't have much hope in the first place?
Okay. So the question is basically, if Thailand gets onto the Human Rights Council, what possible damage or what kind of issues would happen there? What will its presence, I mean, more broadly spoken, what would its presence on the Human Rights Council do or not do?
Yeah, correct. Like, would it be like a damage? Can it be more damage done on the Human Rights Council? Because everybody say Thailand, like everybody like from the human rights background at least say that Thailand should not be in the Human Rights Council. But what if it does get in? Like, what kind of damage would it do to the UN like Human Rights Council system?
Yes.
Okay.
Okay. I guess I'll take that question. I mean, part of the problem, and this is a larger issue connected to the UN and the Human Rights Council, is that there are a number of governments that get onto the Human Rights Council that frankly have no business being there. Prime example is Vietnam. Vietnam sits on the Human Rights Council, and they are hugely problematic. We've also seen in the past China sit on the Human Rights Council, Russia, Cuba, Eritrea. I mean, so there's all sorts of various different seriously rights abusing states that have gotten onto the Human Rights Council. And they seem to go to the Human Rights Council primarily to defend themselves and their friends against any accusations. Now, fortunately, there's no veto at the Human Rights Council, so one government can't hold everything up. And, you know, the outcome is based on a democratic vote of all the member states, one member state, one vote. So a lot of times these rights abusing governments that sit on the Human Rights Council get outvoted at the end of the day. But it doesn't mean they can't cause a lot of problems, and they do. The question I have, I guess, about your question about where does Thailand fit, is that Thailand is perceived to be a government where on thematic issues like LGBT rights or something like that, that they can be a helpful ally, but that on country-specific situations, it's more troublesome, it's more difficult. It's more of an issue where they don't want to single out a particular country, like Vietnam or like Myanmar or like North Korea or something like that. And, you know, I think that what we've seen in the past with Thailand is that they want to get on the Human Rights Council in part also to be in a position to defend themselves and defend their friends. It's very important to a government that's facing human rights criticism to be able to go to another government and say, well, geez, you're on the Human Rights Council, can you help us out here some? You know, the transnational repression that has happened continuously over the past decade in Thailand. You know, I mean, I'm sure that Prayut and Prawit would have loved to have been on the Human Rights Council to defend themselves. So I think there's a game being played here. Thailand is certainly not the worst of the worst. There are many other governments that are much worse than this, but they should be doing a lot better. I mean, this is a democratic state that you know, has recently come out of an important election. You know, the parties that were elected were primarily progressive and had policies that were pro-human rights. So why then is Thailand doing so little? And why is it talking about sending Quynh Bdap, who is a UNHCR recognized refugee, back against all human rights principles?
Thanks for the answer.
Hi, I'm Sally Ensom with AFP. Given all that we've said, thanks so much, by the way, for the excellent presentations. Given all that you've said about, about Thailand and Vietnam, perhaps making this whole issue much more, it could be that Thailand is affected by the need to maintain relations with Vietnam on, good terms. How likely do you think it is? How likely do you think it is that the appeal that you're making will go through for Mr. Bdap? Thank you.
Appeal
Yes.
to somebody, right? Appeal to somebody.
I hope. It's unprecedented, like Tian mentioned earlier, that that we can ever invoke Section 13 from Anti-Torture Act. And we hope that the judge on the appeal court will realize that as the judicial system, they have to use all the law that, invoked during the appeal. Because otherwise this will set a very bad example of who will be used, who can use this non-refoulement, or who is responsible to use. Because the government, if they throw, as it is as of now, they throw the case to the judicial executive branch. But in all of the extradition, the executive branch, they have the authority to make an order whether or not to send or not to send. But one thing at the judicial system need to remember is that they have to consider the right of Quynh Bdap, because he is detained now since the 11th of June, and he can be there for 4 years, like Sok Yeon from Cambodia, that he was detained. And I think if the judicial system follow Sok Yeon case, where they only consider these 4 elements for extradition, the case will be grim. But we have the different aspect is Section 13 of anti-torture that is a tool for the judicial system to use. So we hope they use, and I hope that the outcome will be different and is more respectful to the right of Quynh Bdap, because judicial system have the right to screen the case and end it as soon as possible. They don't have to wait until the case go all the way to the Prime Minister office.
Yeah, I would just add that as someone who was not involved in the actual legal process, that it's rather stunning to me that the court decided to essentially not use the Anti-Torture Act. It sort of put that away and put it on a shelf somewhere, saying, okay, we're just going to talk about the Extradition Act and this other act which is passed and which Thailand has been talking about in its bid for the Human Rights Council, and which everybody has been praising Thailand for, the Anti-Torture, Anti-Enforced Disappearance Act. In the first case where it clearly applies, the court and the prosecutor decide to arbitrarily just set it aside and say, we're not going to talk about that. I mean, what judicial system would allow that to happen? It's rather shocking. Oh, we have a question from the live stream. Do you want to read it? Okay. We have a question from the live stream. Question from the live stream. Do you or UN have any... Okay. Anita, okay, we have another question too. Question from the live stream. Do you or UN have any plan to protect Quynh Bdap and refugee people in Thailand when they are in risk situations?
We are working to protect him right now. We are limited in resources, but we like to work to remind the government that they are obligated to protect everybody in this country, and the international obligation that they promises. And then as they are running for the Human Rights Council, now they have to follow their promises. So the only thing we can do, we are like CSO, we are NGO, we only can remind the government, and in the smaller scale, we give advice of what they can do or cannot do to mitigate the risk. But in the bigger picture, the one that is need to do is the government to step up the game and keep the promise that they are going to protect all the people in Thailand, as stated in constitutional law that is drafted by them. Yeah.
Okay, so in terms of the protection of refugees in Thailand, I think there are several factors to consider, like the sensitivity of the case, whether it could also affect the way we work to protect them. Because in many cases, you cannot speak out loud, and there are different details that as human rights defenders and CSO needs to consider in order to not do no harm to them. But then on the other side, we have the ATA, the Anti-Torture Act, and many provisions would allow you to seek justice for the violations. Like we are working on the enforced disappearance cases of Thai people in neighboring countries. And obviously there are, for example, Article 29 that allows the family of the victims or just the lawyer or anyone, you yourself can also file complaints to the relevant agencies like the, we call it National Committee on the Prevention and Suppression of Torture. So you just need to gather all the facts, like what, where, when, why this violation happens, and then you file the complaint to these agencies. And yeah, but it needs to, you know, as I already said, the sensitive issues you need to consider before doing so and get the consent of the victim families, etc., etc. So in short, CRCF, we are providing these legal assistance to seek justice for the violations, and we are open to like discuss if there is any potential cases we could help with.
Yeah, I just want to mention that we do not want to repeat the history when we sent back the 109 of Uyghurs back to China in 2015. There have been very violation to the non-refoulement principle, even though they the Chinese government trying to prove that these people are involved in the crime action, and they said that if you send them back, you can have like a kind of assurance, or we call like diplomatic assurance, that similarly Vietnam have given to us as well from the Minister of Public Order about that they will not be treated inhumanely. But however, I'll say that even though with this kind of insurance, we still not know about the fate of those Uyghurs that have been deported back until this day. And I say like this is our whole decisions and sovereignty that we have on this case, on like whether we would grant that extradition request or not. And when we do that, there's also another country, the requesting country sovereignty as well, to, you know, do things to people that we don't have any other way to protect them, because we have lost our international protection and we have failed already. Yeah, thank you.
Let me add that this is a recurring problem. In December 2009, Thailand sent over 4,600 Lao Hmong back to, who are refugees and asylum seekers, back to Laos in clear violation of international human rights principles. They were criticized by everyone from Hillary Clinton to the UN Secretary General to the head of UNHCR, but they still did it. And in 2015, they sent back the 109 Uyghurs, where they were basically blindfolded and put on a plane with Chinese police. There's a very chilling video of that if you want to look for it online, which is what Kati was mentioning. We have seen efforts, for instance, to send Hakim Al-Arabi, who was the football player from Bahrain, who was a refugee who had been accepted by Australia and was within months of becoming an Australian citizen, and we had to fight for 6 months to get him not sent back to Bahrain in some sort of deal that Thailand had with Bahrain. And now we're dealing with Quynh Bdap. So there's a recurring problem that within the Thai government, there are these games being played, there are these deals being done, there's this transnational repression being played. And that was supposed to end with the democratic government that was elected in May 2023. Clearly it has not yet, and this is calling it out. And that this is the issue that, when we talk about does Thailand belong on the Human Rights Council, well, maybe if they do the right thing, but right now they continue to do the wrong thing, and they've allowed this case to proceed when it should have been very clear from the outset that Quynh Bdap cannot be sent back to Vietnam because he would face torture and worse, and he should be allowed to go to a third country. This is not rocket science. This person is a UNHCR recognized refugee. And so at the end of the day, we at civil society organizations have to continue to call this out, because if we don't, then the Thai government is just going to trundle along in its ongoing fashion and send refugees back to this place, that place, where they shouldn't be sent. If we're not the watchdogs, then the problems happen in the dark. And that's what we are doing, and as part of that, we are, of course, working with various UN agencies who care about these issues to try to persuade the Thai government not to do the wrong thing. And again, we're back at it again with Quynh Bdap. So, it's sort of a continuous cycle of life here that we once again find ourselves having to fight every single case when it should be obvious from the very beginning that because of who he is and his refugee protection, he should have never been put in this place in the first place.
There's one question there. What is the question there?
Oh no, we have an intervention from someone from China that we'll talk about later.
Oh, okay.
Okay, do we have any more questions? Anything from the live stream? Yeah. Okay, we have another question from the live stream. So another very broad question from the main, what can the UN do to help refugees in Thailand? Who wants to take that one? Well, I can say that UNHCR continues to have a very important role in interviewing and extending person of concern status to people who fear persecution if they're sent back. And the UNHCR plays that role. The UN Office of the High Commissioner for Human Rights plays an important role in advocating for human rights for all people. Those are two very important agencies who are doing the best they can under difficult circumstances. Okay. If there are any more questions in the room? If not, I'm going to call this to a close, just to indicate that, as I said, the coalition of groups that are working on these issues will be coming forward with a letter to the Thai government probably next week. And so stay tuned for that additional news. Obviously, once the decision by the judge is provided to the defense team, there will be an appeal process going forward as well. We are all available after the press conference for any sort of additional discussions or questions you might have. So. Let me thank all the groups involved in this important event. Let me thank the FCCT for hosting us. Again, thank you very much for coming, spending your morning with us today to talk about the very important case of Quynh Bdap and the vital mission of preventing him from being sent back to Vietnam, where he would face torture and worse. Thank you.